Do you need permission to write a book based on your interviews with public figures? Hi, I'm entertainment lawyer Gordon Firemark, and this is Asked and Answered, where I answer common entertainment law questions so you can take your career to the next level. So Stephen has been interviewing some celebrities, and he plans to feature their remarks, their stories and such in a book that he's writing. Some of the interviews are in-person, sit-down kinds of discussions, and some are being done by email, with the celebrities writing their answers to the questions by themselves. So Stephen wants to know, does he have to have these folks' permission to include them in the book? Do they need to sign a release form, even if they write the answers themselves? Well, the answer is this. As you probably realize, celebrities can and do sue when their names or likenesses are used in a way that creates a false endorsement or implies some kind of sponsorship or approval of the material. Now, in the case of an interview included a book, it's probably not a commercial use that would give rise to that kind of right of publicity claim. But a celebrity with a smart lawyer will probably claim that even though there was consent to the interview, you've used it in a way that wasn't authorized. So that's a breach of contract or even maybe a fraud claim. And if the celebrity actually wrote the words you used, that could mean a copyright infringement claim. Sure, you've got a bunch of defenses: free speech, newsworthiness of the content, fair use of copyright material, and there's always the alleged consent. But unless you have something in writing, you're going to be fighting an uphill battle. Written consent is always your best defense. It's your get-out-of-trouble-free card for when these claims come up, however frivolous they might be as they come along. But written consent isn't always possible. Lots of folks get leery when they're presented with a release form to sign. So if you're recording the interview, again, in most states you need consent to do that, you should record the person saying yes in answer to your request. So if it was me, I would start the recorder and say something like, "I'm Gordon Firemark and today is July 3rd, 2015. I'm recording this interview with Susie Starlett. Susie, you understand that I'm recording this interview and you consent to me using this recording as part of my book, which happens to be tentatively entitled Homely Hollywood Harlots, and in all media and languages everywhere in the world, right?" And then you wait for Susie to say, "Yes, of course." Make sure that recording can hear and see, if you've got video, that the person is in fact giving that consent. Now, if the person you're interviewing is a true public figure, someone who's in the public eye because of their work or other events that they've participated in, you're probably okay even without the consent, because the First Amendment provides some protection, at least against the privacy kinds of claims and against defamation claims. But do yourself a favor, get that consent anyway. It's the sure way to beat the lawsuit. Now, in the situation where the celebrity is writing the responses him or herself, you absolutely have to get that written permission to use it. Without it, you're not going to be able to publish your book. The publishers are going to insist on seeing those consents, and they're much harder to get after the interview is over. Now, interestingly, the question of who owns the copyright in an interview is a subject of controversy in copyright law. The Copyright Office has said that it's actually two different copyrights. The interviewer owns the questions and the subject owns the answers. So again, unless you have something in writing, some other proof of the consent and authorization to use the thing, you might have a problem. Just avoid any doubt about things and get a release in writing, if at all possible. And by the way, the same advice goes for anyone creating any kind of media. You're writing a blog, a podcast, doing YouTube videos. If you've got other people's stuff, of whatever kind, in your content, you need to have a release or another agreement to prove you're free to use it. Now, for a free downloadable version of that oral release I just did in here, head on over to firemark.com/interview release. That's all one word, firemark.com/interview release. And to get your question answered here, just visit firemark.com/questions and submit it. I'll see you next time.